SJC-11579, Commonwealth versus Chukwuezi.
Good morning, Mr. Bateman.
Good morning, if it please the court. Stephen Maidman for the defendant, Mr. Chukwuezi. I'd like to first address the issue of the admissibility of the computer-generated simulation, the video. The defendant's contention is that the trial judge erred in refusing to admit the video. It was an abuse of discretion, and the abuse of discretion was that the record shows that the trial judge just did not understand this evidence. Before I get into that, I want to, as a preliminary matter, just address one item that's in the defendant's, the Commonwealth's brief. And that's an allusion to that there was a change in the premises, that the camera somehow had moved between the time of the incident and the time that the video was made. That issue was not either the basis, either explicitly or implicitly, of the judge's decision, and the Commonwealth notes that in their brief. To that extent, it was waived, but there's other evidence that the court should be aware of. There was a jury view in this case, and the prosecutor took the jury and showed all the cameras, in particular this camera, and there was not a mention at all of any changed circumstances there. And
what the changed circumstances would be? What are the circumstances alleged to have been changed?
Well, there was no allegation that the circumstances had been
But what are you rebutting in the Commonwealth?
And the Commonwealth, in the beginning of their arguments, suggest that the video was flawed because it was not established on the record that the circumstances had not changed.
Okay, but
I mean, the location of the location of the camera.
Yes, or anything about the camera for that matter.
but the Commonwealth also argues that there wasn't evidence, or sufficient evidence anyway, that the simulation was taken from exactly where the camera was, that wasn't established in the record. I think I have that right. In other words, that it needed to be, and I think one of the two experts, maybe Garneau, I can't remember which one, had testified, you need to know where the camera was, and I take it that the simulation has to be from where the camera was, right?
Well, there's nothing to suggest that the simulation wasn't from where the camera was.
But the argument is that you need to establish it, and that wasn't done, and I just wonder if you could respond to that.
Well, there certainly was not testimony well, you know, I think it can inferred in the record that it was from that camera. That video was the video that was shown to the jury numerous times. I mean, it was the surveillance video. The only thing that what happened was the defendant's experts sent Mr. Dobson to the site to make all sorts of measurements, basically set up an XYZ coordinate, get all the coordinates of everything. And all that was put into the computer, and there, what was created in the computer were photorealistic images of the figure at varying heights. Mm-hmm. And everything was done with commercially available software. Everything was off the shelf in this case, using principles of photogrammetry.
It's the same team that did Corliss. Well,
I don't know if it was the same team, it was the same firm.
Well, it's also Garneau.
And certainly Mr. Garneau, this is his at least second appearance at this court. And I suspect in the future you're going to see much more of this, given the amount of video surveillance around Boston. This kind of thing is going to come up again.
But you're saying, I take it, that even if it wasn't expressly established, the predicate of the exact location of the video camera, at least it's implicitly established.
Yes. Yes. And there's nothing to suggest that there's anything funny about the way the video was made.
Now, what is the evidence of the height of the defendant?
There were pictures that were taken at the police station with him standing up against the wall. And I'm not sure how much, which ones of the pictures were actually admitted as exhibits. Some of them were. There's no question they were. But had that been an issue in this case, there was ample evidence from the police of how tall this guy was.
That he was 6'1" or 6 feet?
He was 6 feet.
I'm sorry?
6 feet.
6 feet.
Assuming he was standing flush up against the bricks, where you later had evidence to show that a mark was, could
Yeah,
have been, he could have been
that's my
forward. It
understanding
was-
of the record.
Yeah. it
That's my understanding of the
Could
record.
have
So-
been a half inch shorter.
But you know, you really have to view
6
this
feet
video.
with shoes or without shoes?
I'm sure that's not in the, I don't know the answer to that.
Well,
I'm sure
then
it's not in
how,
the record.
and so the best, let's assume that this video had come in.
Mm-hmm.
I saw it, it's not, can't say that I looked at that and said, oh, it's clear that this defendant is less than something. I mean, what do you claim to be the appropriate inference from that video coming
The
in?
appropriate inference, and I'll use the record, and then if you ask me my own personal opinion, I'm watching it God knows how many times, and you can watch it as well. I think the appropriate inference is that the defendant was taller than the shooter. And a
Based
jury,
Okay.
watching this
The defendant
video.
was taller than the shooter. Oh, the defendant was taller than the shooter. Okay, well, how, okay, but what are we talking about? I mean, how much taller?
Depending on how you look at
Defendant 6
inches,
feet, and the shooter therefore was,
5'9",
Well-
5'9" and a half, maybe 5'10".
Mr. Hillman says that the range in the, I think this is right, that the range in the simulation was something like 5'9" to 6 feet or 6'1". I mean, that there was a range in the simulation. Is that not so? That included his height. That's the point.
I'm not sure about that. What they did do, well, if you're asking me, the image was a 5'9" image, 5'10" image, 5'11" image, and 6 foot figure. And and it was when I said that that the trial judge didn't understand the evidence. There were all sorts of terms thrown around at this. Relative height, relative space.
Plus space, what you took up, it's not that you're actually picking someone who is actually in life 6 foot. What you took was the space that,
Yeah.
if you measured the
Right.
space within the image, what you get is something that might be this figure, and you label it as 5'9" or 6 feet.
The easiest way to understand this is that the figure was drawn to scale. And I keep thinking back to
Which figure? The crouching figure, the shooter?
all of them. Those figures were what they purported to be, possibly to who knows how many significant digits. The computer is
In terms of relative space, relative to each other.
drawn
and-
to scale. They were drawn to scale. It's the only way that I can understand it, and I think it can be inferred from the record. That and I keep thinking back to the days when people made model airplanes and model ships. There were certain
But
scale.
those figures were standing straight up figures.
Yes, they were.
And the shooter was the crouching under the umbrella figure.
Well, if you look at the two images that we used, the way Mr. Garneau testified, he said those were the closest to the camera and the farthest away on the sidewalk while standing relatively straight. And one of the things that that I think that the court needs to understand is that right now I'm 6 feet tall, but if I bend over like this, I'm still 6 feet tall.
Yeah, but
Yeah, but that's where we can see you moving.
Well, you can see the movement in the video as well. And the point is, there really wasn't anything
And you
misleading
can, but-
about this.
no, I haven't seen it yet, but it just does seem to me, of course I understand that if you crouch over, you're still 6 feet tall, but if what you're trying to do is have somebody who doesn't know this be able to tell that a crouched over figure is 6 feet versus a person who's standing straight, I just don't get it.
Well, if you look at the video, he wasn't that crouched over. I mean, he was standing relatively tall. I'm not saying he had perfect posture. He certainly wasn't having a back against the wall. But, you know, I think if you view the video, or if the jury were to view the video, he was standing relatively straight. And certainly, it's certainly within the sophistication of the jury, and this would have been, there's no question, there would have been cross-examination galore about the slouch and everything else. You know, it's within the province of the jury, the ability, the sophistication of the jury to look at this, and they would have made their judgment. There would have been evidence that would have been introduced about how tall the guy, how tall the police thought he was. And the jury's looking at him for many days, and they could have formed a judgment, and there was nothing misleading about it. And this was critical evidence in this case. This was an identification case.
Was it misleading? The judge said it was confusing.
Well, she certainly, I think she used the word misleading numerous times, but it wasn't even confusing. This was clearly within the province of the, I mean, we talk about limiting instructions, and put this out of your mind, and other relatively sophisticated thoughts, let alone jury instructions on homicide. This was a video, and it would have been plain to jury. I mean, I don't know how the jury would have come out, but the jurors certainly could have raised reasonable doubt. And this was an identification case.
And was there evidence as to the height of the victim?
I don't think so. I don't believe there was. I mean, maybe the autopsy report probably said, but I don't think even that's in the
No
record.
argument was made with regard to the relative heights of the shooter and the victim.
No, the argument was, I don't think that's correct. The argument was made with respect to the shooter and the superimposed figure.
And the view is that the superimposed figure appeared to be, at 6 feet, appeared to be taller than the shooter
Yes.
in terms of the enlarged view.
Yes.
But no evidence, and I guess I don't remember looking to see what the footwear was of the shooter.
I don't believe you can see it. Maybe you could see it from. Remember, this is surveillance. This was not exactly high. You know.
It's not bad quality though.
No, it's not bad. It's not bad. I mean, this was
Better quality than I had thought it would be from the reading of the briefs. So good quality that nobody could get a better.
They tried. That was
the-
what the trial counsel did. Is they was hoping that they could do facial recognition. Couldn't be done. But on the other hand, photogrammetry, the techniques used in this, you know, this has been around for a long time. And the only difference between
Back to Aristotle, is that right?
well, the argument, yeah, you can find the books. This is not junk science. Most of the maps made in the world are using photogrammetry today, and this type of a defense is going to reappear in this court in the years ahead, only because there's so much video surveillance everywhere around Boston. So it's important, and this was the guy's defense. I mean, he had alibi. There was alibi testimony as well, but it's a totally different thing to show a video to the jury.
No. Do these videos have the capability of determining, you know, relative mass of a person, weight, that kind of thing, given the height?
I think that there was some allusion to that in the record, but that wasn't done in this case. What was done was the first, let's see if we can identify the face. You know, is it him from the video, or is it not him? And when the quality was such they couldn't do that, then they got into the height comparison, and it had to be compared. The guy was wearing a hoodie on his head, and so there was some judgment involved, but there was certainly nothing misleading or confusing about it.
What does our case law say with regard to the admission under Dalbert Lanigan of such things when it's being offered by a defendant in a criminal case as opposed to in a civil case? Is it the same standard?
I've never thought about that. I assume it's the same standard. And by the way, this type of photogrammetry is well beyond a Dalbert challenge. The government uses this all the time. The FBI uses this. There are numerous FBI cases involving FBI testimony on photogrammetry.
So you're saying this was not a Dalbert Lanigan finding by the judge, but a 403 finding, that it was more prejudicial than probative?
to the extent, I'm not sure she used those words, she
No, but
used the
that,
words.
that was the
misleading.
gist of what she was saying, right? It was misleading, confusing, it was,
She,
Right.
my reading, you can go paragraph by paragraph in her ruling, and she did not understand, at least in my view, based on the record, that these figures were scaled, and they were what they purported to be. That was the problem.
But when the Commonwealth objected, what did their motion say? This should not
Junk
come.
science. Initially, junk science.
Junk science is usually a Dalbert Lanigan.
And they made a Dalbert Lanigan thing, never addressed. And they said, in the alternative, we want a voir dire. This would easily surpass a Dalbert Lanigan challenge. There's case law all over America on this, and it's cited, in one of the footnotes in my brief, it's cited. There was nothing funny about the technology, or as they said in Caruso, I'm paraphrasing, the Pythagorean theorem was not invented yesterday. This is basic algebra.
Okay. Thank you then, unless you have anything else you wish to add.
No other question. Let me just briefly address in my remaining time a couple of the other issues. As far as the prosecutorial argument about the family being forced to witness the carnage, that was over the top. The Commonwealth has submitted a 16L letter with another case. That was inappropriate. And given all the
But likely to, the jury would have seen the video of the assassination.
Terrible crime.
It's
Terrible,
not,
no question about that. Terrible crime. But this is supposed to this is an identification case, and it's the issue is, did this guy do it? He testified he didn't do it. At sentencing he said he didn't do it, and then this just throws it over the top even more.
Speaking of that, am I correct that basically the whole case rested on Figueroa's observations? Is there anything?
Yeah, I think that's a very fair comment. Yes, she was the star witness.
But was there anybody else to provide corroboration? There were other people. The person who walked right past them just before the shooting, was he ever identified?
Yes, she was, and
Was
Well,
it she?
the-
Was it he?
Ramona Hartemps. That's who you're
Yes.
referring to.
Oh, that was a woman?
Yeah, it was a woman.
Yes.
She walks by, and then he was shot.
there's three people, actually.
There's a third person.
Isn't there a third person as well?
Yes,
a
there
na-
was
somebody-
Isaiah Grant, who's walking down the street. By the way, they all said he was 5'9", or at least at various times said he was 5'9". I think Amari Figueroa changed her estimate as.
How old was Amari Figueroa?
I think she was a senior at the Burke. Senior.
But she knew him.
Yeah.
Yes, she did know him.
And the other
Did know
witness
him.
had seen, knew the victim, or had seen the victim.
They'd seen the victim at the bus stop, but she did know him. She lived 2 houses down, but she made the.
She had a
There was
nickname.
all sorts of allusions to, and this raises the other issue in the case, all sorts of claims that she was pressured by the police, et cetera, et cetera. And this gets to the prior consistent statement. When she was at the scene, she said she didn't know who did it. Goes to the police station, says she doesn't know who did it. Then at night, she supposedly tells mom that, well, I do know who did it. He lives 2 doors down. She had the motive to fabricate before ever making that prior consistent statement.
And the motive to fabricate is being
She lied to the
scared?
police.
But she talked to her mother before she told the police.
Oh, no. She talked to the police before she talked to the mother.
Ah.
That was the problem with this. This was a prior inconsistent statement.
I'm sorry, I lost you there. I gather, on the night of the shooting occurs early in the morning.
Yes,
At night,
she's talking to mom.
she talks to her mother and said the person who did the shooting lives 2 doors down.
Correct.
And by then, the police had pressured her to identify
She had
the defendant as the shooter.
she had been asked by the police first at the scene at the scene itself. Do you know who did it? And then she goes to police headquarters where they interview her.
Well-
So she already had said. I'm sorry.
No, go ahead, finish.
So they at least twice had told the police either didn't know who did it,
Well,
as I
So
understand
she
the
gave a
record.
general description that matched that of the defendant. She gave a general description. She just didn't say that she knew.
General description.
Right.
Yeah, that's fair.
But did she ever say that the police had mentioned the defendant's name as, so.
They didn't,
So
no.
I don't quite get how you, it's one thing, you know, so basically she says it's the guy who lives 2 doors down before the police even put any pressure on her to identify it as the defendant, that the shooter as the defendant. I don't quite get why that is not a prior consistent statement.
I would suggest that it just shows that she was already prevaricating in various ways to the police, and so therefore she did have the motive to fabricate. That's my point.
All right, thank you.
Okay, thank you.
Good morning, Your Honors. May it please the Court. Zachary Hellman on behalf of the Commonwealth. I would like to acknowledge the family of the victim that is in court this morning. The trial prosecutor expresses his regret that he can't be here this morning. He's out of state. We're asking the court
Was
to...
the trial prosecutor? I couldn't tell from that record.
Excuse me, Your Honor?
Who was the trial prosecutor?
John Pappas, Your Honor. Don't believe that the clock is on yet.
Oh, thank you.
Thank you.
We're asking the court to affirm the defendant's conviction. I'll begin with the video issue. And the issue here wasn't a challenge to the photogrammetry per se. It was the way in which the video was created. And I think it's necessary to provide a little context for the court for Judge Giles' ruling. The engineer testified that there were basically 2 ways in which you could do a height analysis based on video. The first way was if you had multiple cameras, multiple camera angles.
Sorry to interrupt you, but when you say engineer, are you talking about the Commonwealth's witness or the engineer, the defense engineer?
I apologize, Your Honor. Mr. Dobson,
Okay,
the engineer that was hired by Rampion to do the video. He testified there are 2 ways to do a video height analysis. The first way is if you have multiple cameras, multiple camera angles. He didn't have that in this case. The second way is if you have 1 camera, and if you have 1 camera and you take the necessary measurements, you could plug those into a computer program and create a 3D model. And within that model, you could put...
It's only if you have 1 camera.
That's only if you have 1 camera. Within that model, you can then vary the height of an individual if you know all the measurements. But he was asked very specifically, could you do a height analysis could you do a height analysis to determine what the height of a person would be if the person was slouching or walking? He said you could if you had multiple still photographs, say 30. And they didn't have that in this case. So he wasn't able to offer a specific height determination for an individual that would have been walking in this video. So when Judge Giles says that Mr. Dobson didn't have enough information to be able to do an accurate height analysis, my suggestion to the court is that is to what she's referring, which brings to her ultimate conclusion that the video in this case was misleading or would have been misleading to the jury, because the way in which the video was created, by taking these individuals, animated individuals that were, I would suggest, designed to look like the shooter, overlaying them, and then putting a height, flashing a height across the screen, was very suggestive and would have suggested to the jury what the height of that individual, the shooter, would have been, without taking into account any of the variables that were necessary, such as the fact that the shooter was walking, ducking under the umbrella. I would even ask the court to review the video, because I would suggest the feet of the animated shooter don't exactly line up with the shooter on the screen. So in this sense, the video was very misleading, and Judge Giles was well within her discretion in determining that the jury would have been confused by the video.
So is this a 403 determination, or is this a Dalbert-Lanigan determination?
403 determination, Your Honor.
In a criminal case, where it's a tough determination to make, if it's a 403, more prejudicial than probative?
Yes, Your Honor, and I would point out that Judge Giles expressly noted that she was mindful of the fact that evidence like this is generally preferred to be admitted, and the jury could draw their own conclusions. But in this case, she just found the video so misleading that it would have been confusing to the jury to be able to help them in their fact-finding process.
Well, why couldn't cross-examination have dealt with that appropriately?
It could have, perhaps, Your Honor.
But if it could have, isn't that the answer? Doesn't it tilt things in favor of admissibility?
I don't think so, Your Honor. I think that we're looking at whether the judge abused her discretion. And could another judge have admitted this video? Perhaps. But we're looking at whether Judge Giles abused her discretion in this case, and I would suggest that she didn't abuse her discretion. I would point the court to the fact that Judge Kottmeyer in Corliss determined that a video produced by this company would have been misleading, and this court affirmed that ruling. And I would also point the court to Commonwealth versus Caruso, which is 85 Mass App Court 24. It's a case that's cited in my brief. In that case, a judge on a post-conviction motion looked at a video that was created by Rampion that sounds that it was an awful lot like the video in question here. The judge found that it wouldn't have cast doubt on the defendant's conviction, and the appeals court affirmed that judgment and, in fact, raised very serious concerns with the choices that Rampion made in creating that video. So it's tough to say that Judge Giles abused her discretion when other judges...
Could you just, I'm sorry, but summarize again the things that you said were misleading?
Yes. So to begin, the video wasn't meant to be, according to the testimony of Mr. Garneau, the video wasn't meant to be a per se height analysis.
And are you saying that anything that isn't a per se height analysis is misleading?
I'm sorry, Your Honor. Could you repeat the question?
Yeah, I could get it out of the negatives. Are you suggesting that the only kind of video, simulated video in this kind of situation is one that does have a straight height analysis?
No, I'm not suggesting that at all. In fact, I would ask the court to review the photographs that were marked for ID during the voir dire during the testimony of Mr. Green. I actually have copies. I'm happy to submit them to the court if the court would like. That shows what the FBI typically does in a case like this. The FBI basically takes, if you can picture in your mind's eye, a big ruler. And they
Well,
go
that
to
was
the,
in Corliss. That's what they did too.
Yes, Your Honor. And the ruler is placed in the as precise a location as the suspect would have been standing. A video is taken of that ruler, and then that video is overlaid the original video, and the opacity is lessened so that the jury can actually draw a side-by-side comparison from the ruler to the suspect in the screen. That's not what happened here.
No, but that's my question. I mean, that is a straight height analysis as far as I mean, in my limited understanding of this. So, and that's my question, are you saying that's what has to be?
No, I'm not saying that's what has to be. I think that if the video in this case wasn't so suggestive, wasn't so misleading, and it would have been clear to the jury that they weren't suggesting that this is what the particular height of the shooter was, that it was the relative vertical space occupied by that person or thing in the video, I think that would be okay. But that's really not the way that the video came off, and that's not how the video would have been perceived by the jury.
Did I understand you correctly to say that the engineer, or the person who created this video, said it was not intended to be a height analysis?
No, that's what Mr. Garneau, he was the graphic artist. That's what Mr. Garneau, he was the graphic artist who created the video. That's what Mr. Garneau testified to. He's Rampion, I think he's the president of Rampion.
That it wasn't intended.
Was not intended to be a
What was
person.
intended it to be?
It was intended to show the relative amount of vertical space that would have been occupied by the shooter in the scene.
What does that mean?
Is that another way of really trying to say height analysis?
That's what Judge Giles was struggling with, and that's where the confusion and the that's where it became misleading, Your Honor.
Well, I mean, I guess what he was saying is that the vertical space of the shooter was less than the vertical, or was less than the vertical shape of, the vertical shape of the
Space.
Vertical space of the shooter would have been less than somebody who would, than the vertical space of somebody who was 6 feet tall.
That's right, Your Honor, and that leads me to my next point.
Isn't that essentially, I mean, why is that not analogous to a height analysis? I mean, the argument's going to be that the defendant is 6 feet tall and the shooter was less than that.
I think the problem here was that the jury, as Judge Giles found, the confusion would have laid where the jury wouldn't have understood that this was supposed to be a measurement of the vertical space occupied by the shooter. What they would have understood the video to be saying is, this is what the height of the shooter was. And that's not what the video was intended to do.
You mean that they would have thought that one of these, was it three?
Four, Your Honor.
Four. One of those four was the height of the shooter.
That's correct. That's correct.
And that height of the one, and they would have agreed on what that was? Is that what you're saying?
Well, I don't know about that, Your Honor. I mean, I think it's very.
But they would have found one of the four, and that height was, any one of them was different than the defendant's height.
Except from, yes, Your Honor. Which leads me to my next point, which is
What were the four again?
5'9", 5'10", 5'11", and 6 feet.
So 6 feet was the defendant's height, though?
6 feet was the defendant's height.
So
And-
one of the four was the defendant's height?
Yes, Your Honor. Maybe I misunderstood the question. Yes.
Okay.
Can this video technology create a figure that is leaning forward and then straighten the figure out to show what the height would be?
I don't know the answer to that, Your Honor. It's just simply not in the record. It wasn't testified to.
So you were saying the things that were misleading or confusing were that it wasn't meant to be a per se height analysis, but might be taken that way?
It was meant to be a per se height analysis. Yes, I'm sorry. Yes, Your Honor. Yes, I misunderstood.
It wasn't
Yeah, I
meant to be a
misspoke.
per se height analysis, but the jury might be confused into thinking it was?
Yes, and the figures that were placed over the shooter didn't take into account the fact that the shooter was walking, ducking under the umbrella, the thickness of the soles of his sneakers.
And what, explain to me why that matters.
Well, it matters because that all of these factors would have affected the height of the shooter.
Could did the engineer testify that, or the graphic artist testify that they could have done a video that would have been based on a height analysis?
The engineer did testify to that, and that's at pages.
How would that have been created?
Again, he said if you had 30 still photographs taken from the video where you could trace the head path movement of the shooter, you could then attempt to do a height analysis based on the varying heights as he walked, ducked, slouched. But that he didn't have that many still photographs in this case.
And what is the height of the defendant? What's the evidence of that?
The evidence of the height of the defendant is that he was, I would suggest, 5'11" or 6 feet. Two witnesses testified that he was 5'11", Detective Cummings and Sergeant Detective Donovan,
Based on?
based on their own height.
But don't they take a mug shot or something like that with standing in front of a ruler?
That's the second part, Your Honor. Exhibits 41 through 48 are his booking photos. And Justice Duffley, as you noted, the booking photos, he's actually standing a few feet, sorry, I don't want to overestimate,
Inches?
a few inches in front of the cinder block wall. So maybe take an inch, half an inch away from that. My point is,
But the cinder block wall does not have measurements of height?
there's a tape measure that was taped onto it,
And what does it?
Okay,
What
and
did that
what does
show?
that show?
about 6 feet.
But the perspective, if he's forward,
Yes.
do you mean?
would change the the appearance.
So it would be
Yes.
5'11", is that what you're saying?
I would suggest 5'11", 6 feet.
Okay.
Now, I do want to point out that even if Judge Giles was wrong, and even if this video should have come in, it would have been cumulative of the testimony of the unchallenged testimony of Isaiah Grant and Ramona Hartops, both of whom testified that the shooter was 5'9". Now, this is important because not only would the video have been cumulative of that, I would suggest that the court actually would have undermined the best evidence that the defendant had of the discrepancy of the height between himself and the shooter, which was provided by those two witnesses, because
Say that again? It's Isaiah, and who else would have said this?
Isaiah
Ramona
Grant
Hartop.
And
and
the
Ramona Hartops,
Yeah.
And they would have said what about?
they both testified that he was 5'9".
The shooter was 5'9", or that
Shooter
the
was, yes, the shooter was 5'9". The defendant was 6 feet. Now, Mr. Garneau, from Rampion, testified that in his opinion, based on his review of the video, the shooter was upwards of 5'10" and a half, which brings him a lot closer to 6 feet than 5'9" does. So I would suggest to the court that the video would have actually undercut his best evidence, which was the testimony of Ramona Hartops and Isaiah Grant.
Well, I hear what you're saying, but apart from that, it does seem to me that if the jury can visually see something and get their own estimate from what they see, that's a lot better evidence than listening. I mean, since common knowledge, people's estimates of heights are often wildly off. I mean, in other words, it's just not, it's not necessarily considered very probative that people think he's around 5'9".
Well, Yes,
The
yes.
shooter was a 5'9".
Yes, in general, I agree with you, yes. But here we have two witnesses, both of whom say 5'9" explicitly. The defense relied on these two witnesses heavily in his closing argument to argue that he was 5'9". And I encourage the court to review the video because I would suggest that in the video, the purported shooter is closer to 5'10" or 5'11" than 5'9",
And how
which
do we-
again,
and-
I would suggest,
I mean, based on the video.
yes.
Okay, and how tall is there no evidence as to how tall the victim was?
My memory escapes me, Your Honor. I believe that there was an estimate during the testimony of the medical examiner.
The autopsy does not reveal how,
I believe it does, yes.
so, and nobody attempted to compare his height to the height of the shooter since they were only a few feet away?
That's correct, Your Honor.
And nobody asked Figueroa anything about that? I mean, because she saw them talking together.
That's correct. That's correct. And actually, the witness who was most close to the victim and the defendant as they were speaking was Ramona Hartops, and she
Right.
wasn't asked as well.
Okay.
So the Commonwealth's argument, if the shooter was 5'9" and the defendant was 6 feet, then it couldn't be the shooter. Then he couldn't be the shooter.
That was the
That's
defendant's
defendant's
argument.
argument.
Okay. And
Yes.
the Commonwealth's response to that was that they were wrong.
Commonwealth's argument was, listen to Amari Figueroa. She was the person who knew the defendant. She waved to him. She had known him for a significant amount of time. And you see on the video, you actually see the two wave together. And then you see the defendant with his distinctive yellow umbrella walk over, confront the victim, and execute him.
And-
Does the security video show the defendant talking to the victim?
It does, Your Honor.
Are
There are
the
two
shooter talking to the victim?
Yes, Your Honor.
And who's taller?
My memory is that well, it's a little difficult to say because of the angle of the video. But my memory is that the defendant is taller than the victim.
And how tall was the victim?
We don't know.
They don't know.
I can't recall from the medical examiner's testimony, but he was,
But it's in the medical examiner's testimony?
my recollection is, yes, it is. I can't say for 100% sure. But the victim was also just 15 years old, so he was younger than the defendant.
Well, you can be young and tall.
Well, that's true, Your Honor.
Yeah,
That's
but
true.
you also.
That's true.
But I take it, the other thing besides Figueroa is that the Hartops didn't know him, but she did see the person who was talking to the defendant run by, and I'm sorry, talking to the victim, run by and putting something in his pocket, which was
That's
the
exactly
same.
right, Your Honor.
So you've got two people that are.
And not just that, you have Isaiah Grant, as he was walking down Adams Street, he sees, he hears the shots, he sees the person run up the street, jump the fence to go to 17 Forest Street and into the backyard, which is where the defendant lived.
The mugshot at the police station, was the
Yes.
defendant with shoes or without shoes? Or
My
with
recollection is that he was wearing sneakers, Your Honor.
wearing sneakers?
Yes. If the court has no further questions on the video issue, I would just briefly,
I'm sorry,
Yes,
just one other
yes, Your
question,
Honor.
because I thought I took from your brief that you were saying there wasn't, that with respect to the video, the camera had to be the same place as the camera that was in the outside or in the store, wherever, and that there wasn't evidence that it was?
that's right, Your Honor. I do want to acknowledge that this wasn't an argument explicitly made down below, and this wasn't relied on by Judge Giles.
Okay.
But I would suggest that the defendant, as the proponent of this evidence, did have a burden to establish that the camera was in the same exact location, because otherwise all of the measurements would have been skewed, and the 3D model would have been skewed. But
Why
again,
why hasn't he implicitly shown that?
well, there's absolutely no evidence that he went into the store or asked anybody who was associated with that video whether the video camera had been moved, changed, or altered in the year since that they took the measurements since the murder.
And is there not an admission? Your brother says there's essentially an admission by the Commonwealth that it is in the same place because they pointed the jury to it as if it was probative of its location.
I think
Is that not an admission of a party?
I don't know that it's an admission, because I think what the prosecutor was doing was at least showing the jury that it was in the general location of the video when they're out on the view.
Now, is it not the case that Judge Giles did mischaracterize the testimony of one of the individuals who I gather, she said that he said essentially this is one way to do it, but there are other ways to do it which we did not apply, and she understood that to say that you can't do it with the one way that we had.
I disagree. Again, Your Honor, I would point the court to, I believe it's pages 12 to about 17 of Volume 8, and I think this is where she's getting, this is the testimony that she's relying on when she makes her ruling. Again, she has a very specific question to Mr. Dobson, and that is, could you determine the height if an individual is slouching or walking? And he says, I could if I had 30 or so frames in which I could trace the height of the head through the video. He didn't have that, so he didn't do that. Again, he wasn't asked to do anything more in this case than take the measurements whatsoever. So I don't think that she's mischaracterizing or misunderstanding what Mr. Dobson testified to when she says that he would want more information. I think that's accurate. He didn't have the methods, he didn't have enough camera angles to do the 2-camera or multiple camera method. And with respect to the 1-camera method, he didn't have enough frames, or there were not enough frames before him to be able to do an accurate analysis based on someone who was slouching or walking.
Well, if that was the case, why did the video show heights of 5'9", 5'10", 5'11", and 6 feet?
Again, Your Honor, and I think this is where it gets so confusing, is it was meant to be the relative vertical space of someone or something in that precise area where the shooter was standing. But what the video shows, in actuality, is, I would suggest, it's very suggestive because it shows the jury what the shooter's height was without taking into account any of those variables.
Okay, thank you.
Thank you very much, Your Honors.